English laws in a neighboring province, establishing therein an arbitrary government. Gee, that sounds like a military dictatorship. And enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule. Gee, that sounds like another military dictatorship. He has abdicated government here by declaring us out of his protection and waging war against us. Gee, that sounds like martial law. For protecting them by a mock trial. Gee, that sounds like martial law, a show trial. And you know, in the colonial days, they couldn't get a conviction in the colonies, and they had to take people to England to put them on trial to get a conviction. That's true. That's the power of the jury, okay? That's the power of the jury, and you have to understand that, and everybody should be telling people about the power of the jury, because a lot of this stuff would come to an end if people really understood the law and how the law works, and their rights and duties as a juror, because all of this stuff would end, you know, because if they couldn't get a conviction, they wouldn't even be putting you on trial. Cause of necessity from taking up arms, okay? That was the Declaration of Independence. This is the cause of necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use of the exercise of the law martial. It's exactly what's going on today. And for altering fundamentally the form of government established by charter. We saw the miseries to which such despotism, military dictatorship, would reduce us. That's what a despotism is. It's a dictatorship.
Isn't that what's happening every day here?
It's absolutely.
People, the cops clubbing people,
yeah.
you know, on the side of the road.
Absolutely.
Well,
Absolutely.
Police state.
Yeah, yeah, but that's despotism. That's making war on us. That's all of these things.
Yeah.
The Magna Carta is full of evidence that it was precipitated by martial law rule. Magna Carta, chapter 45. We will appoint as justices, constables, sheriffs, and bailiffs only such as know the law of the realm and mean to observe it well. To none will we sell. To none will we refuse or delay right or justice. Obviously, they were selling justice. They were refusing justice. They were delaying it. I mean, think about it. That's exactly what they were doing. That's why they had to put it in there. It's the same stuff they're doing today. There are chapters describing how they're stealing people's wood and people's horses and people's carts. Law merchant is private international law. They're violating chapter 38 of the Magna Carta. No bailiff for the future shall put his unsupported, upon his unsupported complaint, put anyone to his law without credible witnesses. So they were sitting there saying, well, you just violated this law. Well, where does it say I have to do it? It's a fictitious law. Remember, color of law? So it's a fictitious law. It doesn't exist. And they do that all the time. No freeman shall be taken or imprisoned or seized or exiled in any way destroyed, nor we go upon him nor send upon him except by the lawful judgment of his peers or the law of the land. The reason that's there is because they were doing that. And they're doing it again. There are certain words that are used in martial law: residence, traffic, commissioner, drive, human. We talked about these already. We have no more right to decline the exercise of jurisdiction which is given than to assert that which is not given. The one or the other would be treason. Every nation on the planet's under martial law, and it's probably almost. I tend to think that Ukraine may not be. Maybe Russian isn't either. Putin's a really good guy, I think. Anyways. Bottom line, all of this martial law stuff is for Ford and GM. If you're a Ford or GM employee, then you're a slave. If you want to be free, then we the people have to quit letting Ford and GM run the country. We have to just quit participating. Whose duty is it to protect the Constitution? The courts ruled that the government is not the protector of the Constitution. If the government's not the protector, then who is? It's up to we the people. Nobody said it'd be easy, but it is possible. Resistance to tyranny is service to God. Do you know who you are? When plunder becomes a way of life for a group of men, they create for themselves in the course of time a legal system that authorizes it and a moral code that glorifies it. And that's best yet.
Can you go back one more for that?
If you have 10,000 regulations, you destroy all respect for the law. What's the alternative? There's the cross. Live free or die. You know, really. Do you know who you are? I get a little excited sometimes. It's so obvious, the stuff, the shit that's going on.
Do you check that email pretty regularly, that engineerwin?
Oh, yeah. Several times a day when I have internet. The problem is that where I'm at, I don't have much internet, so. Okay. We did commerce yesterday, right? We didn't do courts. We haven't done land titles yet.
Is there like a short one we could do and maybe have a little bit earlier lunch? I don't know how people feel about that. About like 1:30, 2 o'clock.
We could do void judgments. That'd be fairly short. Let's do void judgments.
You're the boss.
Oh. Yeah, the void judgments, this is 41, so it's a short one.
Can we commit to that and then do lunch? How does everyone feel about that?
Huh?
Yeah? Larry?
What time is it?
Void judgments.
20 after
It's 20 after 12 here. Void judgments. The courts have decreed that want of jurisdiction makes all acts of judges, magistrates, U.S. Marshals, sheriffs, local police, all void. Not just voidable, void. A voidable judgment is one apparently valid, but in truth wanting in some material respect. When there is no jurisdiction, there is no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Say, and that's Coke. Okay, that's citing Coke. And that's cited in a U.S. court case, U.S. Supreme Court there, but that's citing Coke. So that's England. A void judgment is one which from its inception was a complete nullity and without legal effect. A void judgment is one which has no legal force or effect whatever. It is an absolute nullity. Its invalidity may be asserted by any person whose rights are affected at any time and at any place. It need not be attacked directly, but may be attacked collaterally, whenever and wherever it is interposed. Do you know what a collateral attack is?
No.
Collateral attack, in their rules, it tells you that you have so much time to file an appeal and all the rest of it, right? Well, all of that can expire, and you can still come back and attack it. You can attack it all day long, and from all sorts of directions, and it's perfectly fine. Because it's a void judgment. It's nothing.
What's
Okay.
an example of that?
Huh?
Look at a scenario where you do that.
Well, like in my case, for example, okay? I plan on attacking that judgment of the Court of Appeals that wouldn't, matter of fact, if it gets, my case goes to the Court of Appeals, I'm gonna dump on them. But I'm just gonna really dump on them. But that Court of Appeals decision, that wouldn't let me file my appeal without paying their extortion, eh? And so, and the lower court's judgment, Langston, I'm not gonna dump on him too much, because I'm hoping that same lower court, whether it's him or someone else, will give me that writ of prohibition. See what I'm saying? But I'm gonna call his judgment a void judgment, for sure. And the void judgment is also the customs issue that's right now. You see what I'm saying? That's a good example right there. So I don't have to, I can challenge that 6 months from now, I can challenge that 5 years from now. And where times for appeal and everything, you know, in other words, you know, I could actually get convicted and go to jail, and I could still challenge it as a void judgment 10 years from now.
Because it's fraud, it's a fraudulent
It's a fraud from the
judgment,
beginning.
So there is
That's
no statute of limitations
that's
on
right.
fraud.
Exactly.
And I think if you submit an affidavit stating you don't accept the jurisdiction, any judgment against that affidavit is a fraud, because you've asserted that you're not consenting to their jurisdiction.
Well,
technically, am I right or wrong?
And that's what I've challenged all along.
Yeah.
See what I'm saying?
Yeah.
So it's on the record. And so, but they're trying to railroad me. But again, the judge in the lower court told me what I need to do. He says I need to bring an action in Queen's Bench. So that's what I'm gonna do. And you know, we'll see what happens, you know? So anyways, a void judgment insofar as purports to be a pronouncement of the court is an absolute nullity. A void order may be attacked either directly or collaterally at any time. A void judgment is one in which from its inception is and forever continues to be absolutely null, without legal efficacy, ineffectual to bind the parties or to support a right, of no legal force and effect whatever, and incapable of enforcement in any manner to any degree. So, if you think about it, anything that happens to you, especially when you challenge jurisdiction, okay, you challenge it up front, you do it properly. 10 years from now, say the government, there's a revolution, okay, you can challenge all of that. You can bring it up after and say that's all void, and I demand a remedy. These guys damaged me, I demand a remedy, and I demand it now. And you can do that. See what I'm saying? Even if you wind up going to jail for 20 years. You see what I'm saying? Based on these trumped up charges when they didn't have jurisdiction. Absolutely. And so, you know, by me putting this stuff in there, they know that what I'm saying is right. And it makes it very difficult for them to proceed, because they know sooner or later they're going to pay the piper. And the more they abuse me, the worse it'll be for them. Because judgment's coming, whether it's tomorrow or next week or next year or 5 years from now.
Or up there.
Huh?
Or up there.
Or wherever, that's right. A void judgment is one which from its inception is and forever continues to be absolutely null, without legal efficacy. Oh, I read it. Bruin and Pullman, I think we already read that one. An empty noise. Do I hear some Bruin and Pullman going on here?
Is that like Charlie Brown's teacher?
Yeah, there you go. Not every action of a judge by any judge is an exercise of his judicial function. We read that one already. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. And by me telling him that, he's walking a fine line. And that's why he's helping me a little bit. You see what I'm saying? That judge in that lower court, that's why he's nice to me. That's why he's helping me a little bit, because he knows he's walking a fine line now, because his immunity might be on the line.
Well, and he gets you out of this court into the next one.
Well, that too. Okay, puts it into, see if I file an action in the Queen's Bench and I lose, well then that supports him. You see what I'm saying? If I file an action in Queen's Bench and I win, well then he's off the hook too. Either way, it's a win-win. So he needed to tell me what I needed to do. He was helping me, but he really had to. Okay, you think about that.
Yeah.
You think about that. So again, if you have your ducks in a row, they will help you. They have to. Okay, they know the law. When enforcing mere statutes, judges of all courts do not act judicially. Okay, that judge in that provincial court, he's not a judge. Okay, he's an administrator. He's already told me that. And are thus not protected by qualified or limited immunity, but merely act as an extension of an agent for the involved agency, but only in a ministerial and not a discretionary capacity. In other words, he has to do what the Crown tells him. It's a show trial. It's a fraud, everything that goes on. Immunity for judges does not extend to acts which are clearly outside their jurisdiction. Okay? So you understand what's going on. Where any state proceeds against a private individual in a judicial form, it is well settled that the state, county, municipality, etc. waives any immunity that counters cross-claims and complaints by direct or collateral means. Remember? Void judgment again. So you can challenge it as long as you can show there's void judgment. The jurisdiction issue is the one that's always the most important thing that you can ever do, and that's the purpose of my notices, okay? That's the purpose of serving them with stuff by registered mail, because you want to lay the foundation for that jurisdiction issue. The government is but an agency to the state being the sovereign people. When acting to enforce a statute and its subsequent amendments to the present day, the judge of a municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such power are necessarily nullities. This is England. Okay, those other cases were U.S., obviously. Well, these are English cases now. A plaintiff has no right to obtain any judgment of all. This is talking about void proceedings. In Fry versus Moore, said of void and irregular proceedings, it may be difficult to draw the exact line between nullity and irregularity. If a procedure is irregular, it can be waived by the defendant, but if it's null, it cannot be waived, and all that is done afterwards is void. In general, one can easily see on which side of the line that particular case falls. A void order results from a fundamental defect in proceedings. Remember, jurisdiction is a fundamental defect. If they don't have jurisdiction, they have nothing. Or from without jurisdiction. Matter of fact, they're talking about it here. Ultra vires act of public body or judicial office holder. Okay? And that's another argument I'm making, is they don't have the authority to do this. Ultra vires, that's what they're talking about. It's not authorized within their corporate charter. A fundamental defect includes a failure to serve process where service of process is required, or where service of proceedings never came to the notice of the defendant, or where there is a fundamental defect in the issuing of proceedings so that the effect of the proceedings have never started, or where proceedings appear to be duly issued but fail to comply with a statutory requirement. Failure to comply with a statutory requirement includes rules made pursuant to a statute. A without jurisdiction ultra vires act is any act which a court does not have power to do. In Peacock versus Bell, it was held that nothing shall be intended to be out of the jurisdiction of the superior court, but that which especially appears to be so, and nothing shall be intended to be within the jurisdiction of an inferior court, which is so expressly stated. And that's true. That actually should be in the court's presentation. It is important to note, therefore, that the case of orders of courts within unlimited jurisdiction can never be void unless an unlimited jurisdiction is limited in situations where it is expressly shown to be so. In the case of orders of courts of unlimited jurisdiction where the jurisdiction is not expressly shown to be limited, the orders are either irregular or regular. Now, you have to understand that customs is a court. I mean, you think about it, it's an administrative proceeding, but they have a limited jurisdiction, okay? They don't have unlimited jurisdiction. So I'm challenging customs jurisdiction. They brought this action into the court, which is provincial court, and I'm not sure about whether that's a court of limited jurisdiction or general jurisdiction. But the bottom line is, though, is it's customs that I'm challenging their jurisdiction. And that's clearly limited because they only have jurisdiction right there at the border. They don't have jurisdiction anywhere else. You see what I'm saying? And so their jurisdiction's limited. They're definitely inferior.
And they're federal.
And they're federal, exactly. Yeah. Exactly. There's a whole bunch of reasons why they don't have jurisdiction. Anyways, if irregular, it can be set aside by the court and made upon an application to that court to a person affected by the irregular order. If it is regular, it can only be set aside by an appellate court. So some things have to be appealed, and some things don't. But Queen's Bench is a proper appellate court in this case because it's superior to the provincial court. And the judge actually told me that I need to file something into the Queen's Bench. See what I'm saying? Anyways, similarly, if the higher court's order is founded on a lower court's void act or invalid claim, then the higher court's decision will also be void. See? That's true. So essentially what they're saying is you have a void judgment, then everything that flows from it is also void. A void order or claim has no legal effect from the beginning and therefore does not need to be appealed, although for convenience it may sometimes be necessary to have it set aside. Whereas a voidable order or claim has legal effect unless and until it is set aside. Therefore, while a void order or a claim does not have to be obeyed and can be ignored, and its nullity can be relied on as a defense when necessary, a voidable order or claim has to be obeyed and cannot be ignored unless and until it is set aside. A void order can be set aside by the court which made the order because the court has inherent jurisdiction to set aside its own order, whereas a voidable order can only be set aside by an appeal. A person affected by both a void or voidable order has the right to have the order set aside, which means the court does not have discretion to refuse or set aside the order or to go into the merits of the case. In other words, once I bring up the issue of the void order, they can't go into the merits of the case, okay? If I show that it's void, then they just have to void it, and that's
Nobody
it.
killed the guy, it doesn't matter, it's void.
Right, exactly, yeah. Or something serious happened as a result. You see what I'm saying? Anyways, the procedure for setting aside a void order is by application to the court which made the void order, although it can also be set aside by appeal, although appeal is not necessary, or it can be quashed or declared invalid by judicial review, or where damages may also be claimed, and I guarantee you that's going to be the next discussion. Although an appeal is not necessary to set aside a void order, if permission to appeal is requested, and if out of time, the court should grant permission because time does not run because the order is void, and the person affected by it has the right to have it set aside. A void order is incurably void, and all proceedings based on an invalid claim or void act are also void. Even a decision of the higher courts will be void if the decision is founded upon an invalid claim or void act, because something cannot be founded on nothing. A void order is void even if it results in a failure of natural justice or injustice to an innocent third party. That's true. It is never too late to raise the issue of nullity, and a person can ignore the void order or claim and raise it as a defense when necessary. The House of Lords confirmed that there is no valid trial if the bill or indictment has not been signed by an appropriate officer of the court, because Parliament intended that the indictment be signed. A thing void in the beginning does not become valid by lapse of time. This is actually maximum law. Time cannot render valid an act void in its origin. Things invalid from the beginning cannot be made valid by some subsequent act. Okay? If it's void, it doesn't exist. It's a nullity. Okay? That's what a nullity is. Once a fraud, always a fraud. What is otherwise good and just, if sought by force or fraud, becomes bad and unjust. And so that applies to customs. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may be, by change of circumstances. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may be, by change of circumstance, become his own. And basically that's saying that you guys, it would really be appreciated if you guys help me out with this, because otherwise it's gonna, could become your own issue. So it helps everybody, and so you're on the right track by networking with Larry and the meetings and coordinating your efforts and all of that stuff. So that's definitely, you're on the right path, and you need to keep going. If you love wealth better than liberty, the tranquility of servitude better than animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you are ever our countrymen. and that's Samuel Adams. Do you know who you are? Never give up. That one's not the cross, eh? Yes.
Why do judges not sign their decisions?
I haven't seen that in Canada.
Oh, yeah.
Depends on which court. Depends on
I
which
haven't
court.
seen any signature, like even on a speeding ticket. They send you this thing, they call it a
Well,
bill. There's nothing on there.
Well, that's
Nothing.
provincial court for one thing,
Yeah.
And-
But I
and
was,
that's administrative, that's admiralty proceeding, okay? That's further evidence that it's an admiralty proceeding. Common law, they sign it. When I did my lawsuit and it got dismissed 3 years ago, in the Court of Queen's Bench, the judge signed that order.
really,
Uh-huh.
because I got convicted in income tax court.
Oh, well, that's again admiralty. That's clearly admiralty. We just talked about that.
But there was no signature on it at all.
Of course not. It's admiralty.
Yeah.
Was there a stamp? Was there a judge's
No,
name in there?
Not even a stamp.
Yeah, no doubt. That's admiralty. Again,
So
so you
can I
didn't
do
get
this?
convicted. It was your Sister K Trust that got convicted. You have to
Yeah,
understand that.
yeah, so can I do this?
Yes. Well, it depends on the issues you brought up. Did you bring up the issue of jurisdiction?
God, it's so many years ago, I can't remember.
You have to bring up the right issues. Did we do attorneys already? I think we did, didn't we?
No,
No?
No, no.
I think we were gonna do lunch.
Okay, yeah, well, we'll do attorneys when we come back. It's not a very big one anyways, but let's go to lunch.
Well, it's only